Hi everyone. So next what we discuss is the Union and State Council of Ministers, the detail that we'll see here. In this particular video, we will discuss the introduction. We will see the status of the Council of Ministers, and for understanding that status, the reference that we'll be using is Article 74 and 163 because we are doing both Union and State Council of Ministers. What I've done is to break this entire broader topic into several smaller segments that will include the section on PM and CMN as well, Council of Ministers and Cabinet, the differences, the role, etc. And then Attorney General and Advocate General. All the details and the timeline, the schedules, everything I have shared in the Telegram. So please do check the channel. The link is given in the description section so that you have all the details beforehand. What will be the class timing? What are the dates on which the topics would be covered? Now we'll continue the discussion here. So the first thing that we have to understand is that why do we have this system? So as you know that because of the existence of, or let's say the prevalent parliamentary system which is provided to us by the Constitution of India, and this parliamentary system is there in both the center and the state. Now this is modeled on the British pattern, the British parliamentary system, with certain differences we have borrowed here. Now because it is modeled on the British pattern, तो British में क्या होता है? The British Crown actually acts on the advice of the ministers who are responsible. Please notice all the keywords here because we will have to see that the words like aid and advise, the words like responsible, all of that we'll find in our constitution also. So the British Crown acts on the advice of the ministers who are responsible to the popular house of legislature. So on this similar basis, we have the system wherein we will have a responsible government, and you will see this point of collective responsibility also. So we'll have the responsible government in the context of the parliamentary system, and therefore because we follow this, so what do we have is the president acting as the constitutional head or nominal head. Similar would go for governor, and the prime minister or the chief minister acting as the real head. Even if we have said that our system is modeled on the British line and there are similarities, but there are certain differences also. Of course, there are multiple differences which we have seen in the the parliamentary system, but here the what difference we are trying to see is with respect to the placing of the cabinet system. Only one difference we'll see here. So in the case of British Constitution, what you have is that the cabinet system is left to convention. And here in the Indian Constitution system, the foundation of cabinet system is already given in the written constitution. Definitely how it will work, etc., is taken care of by considering the convention also, but otherwise the foundation is given in the written constitution. Here the cabinet system is left to the convention, and crown gets all the powers, and ministers just for the namesake they work under the crown. Okay, now we have understood about the similarities and the differences, and therefore we have to notice that this principle of parliamentary system that we talk about is not given as such in any detailed format in the constitution. So it is not given in the detailed format, but broadly is covered in 4 articles. And what are the 4 articles? 74 and 5 for the union, and 163 and 4 for the state executive. Therefore, these two will do today. These two will be the content for the next lecture. I hope the introduction of this Council of Ministers thing is clear to you. When we talk about these two, the 74 and the 163, they are actually dealing with the status of Council of Ministers, which we'll do just now. And they are dealing with the other provisions about Council of Ministers, like their, oath, salary, etc., etc. So all of those things we'll see in the next video. So here our focus is on the status of the Union and the State Council of Ministers, and therefore, as I said, we'll do the details of 74 and 163 article. Now, when we do these articles, we'll have to see the basic content also, which is given verbatim here. What does this say? It says that, although we have done it briefly, but now in detail we'll cover. Council of Ministers to aid and advise the President. So 74 is about Union, therefore President. So it says there shall be a Council of Ministers with Prime Minister at the head. So there will be a Council of Ministers which will be headed by the Prime Minister. To aid and advise. What will be the work of that Council of Ministers? To advise and help the President, who shall, in the exercise of his function, act in accordance with such advice. Now please notice what is given for President, that the President the President shall act in accordance with that advice, which means it is binding. The advice of the Council of Ministers is binding on the President. And you will also notice this has been inserted later in the original constitution. So this is inserted or substituted by the Constitution 42nd Amendment Act. So this binding thing is done by the 42nd Amendment Act 1976. Along with that, certain other thing is inserted by 44th Amendment Act also, that the President, if feels that the advice of Council of Ministers need certain reconsideration, need certain change, then the President may require the COM. Require means ask here. So may ask the Council of Ministers that please reconsider this advice that you have given me, generally also, or maybe otherwise for some reason also. And the President shall act in accordance with the advice tendered after such reconsideration. Now understand. Let's say this is Council of Ministers headed by Prime Minister is giving aid and advice to the President. The President gets the advice and feels that there needs to be some reconsideration of that advice. The President asks the Council of Ministers to reconsider. When this happens, the Council of Ministers has two choices. Either send back the same advice without any reconsideration, or let's say without any change, or send changed advice, some modified. These two possibilities are there. Whatever is the case, whatever advice comes to the President second time, changed or unchanged, the President is bound to have agree to it. I hope you are getting the idea. So the President anyways has to act accordance to the aid and advice of the COM. The next clause says the question whether any, and if so what. So whether any advice, or if any advice was given, then what was that advice? Both of these questions, whether any advice was given or what was the advice given. So any such question given by the ministers to the President shall not be inquired into any court. So any court, यहाँ पर आप judiciary को prevent कर रहे हो, आप checks and balances में इस example को याद रख सकते हैं, ठीक है? That the judiciary is prevented to intervene in this matter, in this executive thing, that the President, whatever advice, if getting from the COM, that question will not be inquired in any court. And this is kind of showing the intimate and the confidential relationship that exists between the President and the Council of Ministers. Right? So these are the details for 74. Next is 75, which we don't need to do right now. Next we'll see the counterpart for this. तो हम इसको गवर्नर के केस में देखेंगे. The things are same except one thing which you have already done in the discretionary power, so it shouldn't be a problem to you. Let's repeat this. So it says there shall be a council of minister with a chief minister at the head. So वहाँ पे prime minister is the head, यहाँ पे chief minister is the head, because हम state executive देख रहे हैं. So CM at the head to aid and advise the governor in exercise of his functions. एक condition दी गई है, except in so far as he is by or under this constitution required to exercise this function in the discretion. So the discretionary power is there with the governor. It was not with the president. The president is bound to act according to the advice. The governor, in the situations wherein has discretion, has to work, can work in the discretion. However, later Supreme Court gave a clarification on this. So I'll just explain that in some time. Let us just finish the two clauses also, because this article is not that lengthy, so that you have the basis of the comparison. Now the question is कि अब ये कौन decide करेगा कि discretion में कब act करना है कब नहीं, right? या फिर the matter is needing that. So if any question arises, whether any matter is or is not as respects which the governor is by or under this constitution required to act in this discretion. So if any question relates to any matter wherein the question is कि governor को discretion में act करना है या नहीं करना है, then the decision of the governor in this discretion will be final. So basically the deciding authority for discretionary matters will also be the governor only, and any act done by him, उस चीज़ की validity will not be called in question on the ground that he ought or ought not to have acted in his discretion. इस चीज़ पे कोई question नहीं उठाएगा whether he acted in discretion or not, he was supposed to act in discretion or not, nothing like that. Discretion पे decision is final of governor, that is it. I hope that is clear. And this point is very, very same to what we have just done here in the case of president, that the question कि क्या advice दिया गया नहीं दिया गया, अगर दिया गया तो क्या दिया गया, any such question will not be inquired into any court. Now I hope this is clear. अब यहाँ पे आपको distinctions बहुत clear समझ में आ जा रहे हैं. So there is nothing much to be worrying here about. That was about the status and the details. But एक चीज़ जो आपको याद रखनी है, that this article 74 and 163 is mandatory. This is not directly given in the constitution. ये Supreme Court judgment से आया बाद में. What is mandatory? मतलब that a council of minister has to be there to aid and advise the president or governor. So let's say council of ministers जो हैं वो ये तो resign कर दे रहे हैं, ठीक है, या फिर let's say कि there is dissolution of लोक सभा, तो भी ये ministers जो हैं वो नहीं रहेंगे. For whatever reason, अगर council of ministers वैसे नहीं भी exist करते हैं तो भी they will have to be in office till successor comes. If you remember हमने president और vice president के केस में भी ये सब देखा था कि और गवर्नर के केस में भी कि जब तक नए सक्सेसर नहीं आ जाते हैं किसी तरीके का गैप नहीं होना चाहिए ऑफिस में, वैकेंसी नहीं रहनी चाहिए, कोई ना कोई वहाँ पर रहेगा ही रहेगा. So even if this happens, the council of minister will have to be, there will always be the need of council of minister to act, to aid and advise the president and governor. And if this doesn't happen, it will be considered that these two articles are being violated. And this was very clearly mentioned by Supreme Court. 1971 में ये बात उन्होंने बोला. फिर 1974 में सुप्रीम कोर्ट ने एक और बात कही. क्या कही कि in anywhere in the constitution if it is written that it has to be decided on the basis of the satisfaction of president, because 76 में इसको मैंडेटरी कर ही दिया गया था, बट तब तक मैंडेटरी की बात नहीं की गई थी. ये कहा गया था कि अगर ये सेटिस्फैक्शन की बात होगी सो इट विल नॉट बी द इंडिविजुअल सेटिस्फैक्शन. भले वो मेंशन होगा दैट सेटिस्फैक्शन ऑफ प्रेसिडेंट, बट इट विल मीन दैट हियर वी आर टॉकिंग अबाउट द सेटिस्फैक्शन ऑफ द काउंसिल ऑफ मिनिस्टर्स, बिकॉज उन्हीं के एडवाइस से प्रेसिडेंट को काम करना है. और ये भी कहा गया that except the discretional situation of governor, that we have already seen in the previous video, that what are the discretional situations wherein the governor acts in discretion. So except discretional situations, governor has to act in aid and advice of COM. The governor cannot say that I will work without COM, or the governor will also not go against COM. So even though the constitution as such has not binded, लेकिन कोर्ट ने कहा कि अगर डिस्क्रिशनल सिचुएशन है जेन्युइनली तो ही आप अपने से काम करोगे, अदरवाइज दे ऑल्सो हैव टू लिसन टू द काउंसिल ऑफ मिनिस्टर्स. So these are all the details related to the introduction of the Council of Ministers, the status which is given in Article 74 and 163. In the next video, we'll continue with the next pointers wherein we'll see the other provisions with respect to the Council of Ministers. Hope you guys are liking the session. Please do respond in the comment section so that I get to know about your feedback. Thank you so much guys. Take care. We'll see you in the next one. Bye bye.